So, good morning or good afternoon, dear ladies and gentlemen. It is my sincere pleasure to welcome you to today's panel discussion. We are glad you will be joining us today in taking a closer look at international turnkey contracting in Southeast Asia. Given the still rising number of engineering, procurement, construction, or for short, EPC projects in the region, our local experts from Indonesia, Thailand, and Vietnam will be more than happy to share their expertise with you and to discuss and highlight the specific challenges, stumbling blocks, and of course, opportunities of EPC projects in their specific legislation. Before leaving the stage to Markus Schlüter, head of our Cologne-based ASEAN desk, and today's moderator and my dear colleagues, please allow me to quickly guide you through the technical side of our program. In the top right corner of your screen, you will find the control panel. Here you may basically adjust your audio settings and choose between your headset or computer audio. Please note that as an attendee, you are muted by default, so taking a sip of coffee or taking a bite is no problem at all for you. A little further down, you will find the question panel. Please insert all your comments or questions here for us to take care of. Please do so with your topical questions, of course, and we'll be happy to attend to these in the end in our Q&A session. But do also please feel free to leave your comments on technical issues here. Should you experience any technical hiccups during the session, we will be happy to support in the background and assist with anything that might occur, though we, of course, hope it doesn't. So with that being said, it is now my pleasure to leave the stage to Markus and my dear colleagues. Enjoy.
Many thanks, Bettina, for this introduction, and also from my side, a warm welcome to all participants in our today's panel discussion. Bettina mentioned already my person. I'm here heading the ASEAN desk in Germany, but I would, of course, also like to introduce you to our panelists of today's session. In alphabetical order, we have Martin Kommetzka from our Bangkok office. Martin is a lawyer heading our legal department in Thailand and has many years of experience in Thailand with foreign direct investment matters, but also project-related matters and EPC projects. Then we have Stefan Evers. He's heading our Indonesia business based in Jakarta. He previously worked in other ASEAN jurisdictions, especially heading our Vietnam offices for 8 years. So also Stefan comes with lots of practical experience that we would like to share today. And last but not least, we have Michael Vegeta. He is now the head of our Vietnam practice, and he previously worked several years in our offices in Delhi and Kuala Lumpur, also a German lawyer. Today we discuss local aspects of turnkey projects. I assume most of you are already familiar with these types of projects. Just a little word of background. Turnkey projects are commonly understood in international business as arrangements in which a company contracts with another to build complete, ready to operate facilities, which commonly includes the supply, erection, and commissioning of plants or complex machinery. The scope of such engineering, procurement, and construction operations, today we will use the common abbreviation EPC, mostly include design, delivery, construction, installation, commissioning, and startup of equipment on the project owner's side. The use of a FIDIC model contract is quite common in most ASEAN countries, subject, of course, to adjustment in view of specific local regulations. The major share of these EPC services are conducted in the field of industrial equipment, manufacturing, and construction. The number of these projects in Southeast Asia has strongly increased in the last 2 decades amid the ongoing liberalization of certain economies, particularly the electricity sector, where deregulation in many countries has enabled independent power producers to enter the market. We have also seen some operation concessions for investors in water treatment systems, for example, and of course a vast flow of projects with business partners in the private sectors and a broad range of industries. In this panel discussion, we take a comparative look at essential aspects for contractors doing business in Southeast Asia, and we specifically picked 3 jurisdictions: Indonesia, Thailand, and Vietnam. But many of the considerations also play a comparable role in other ASEAN jurisdictions. We start with taxation aspects and then followed by a look at relevant local investment and immigration regulations that should be considered when planning EPC projects in the region. So in the planning stage of an EPC project, most contractors are generally aware of the need to consider local and international tax implications, which, depending on the project duration, can trigger a permanent establishment with specific tax risks. In this context, split EPC contracts, which are specifically tailored to the particular country, are quite common in most ASEAN countries by developers to reduce the tax exposure. So it's a concept that you might also know from other jurisdictions worldwide. The background for such splitting, which is often done under an umbrella agreement, is that the nature of these contracts consists of both supply of services, for example, design, installation, or commissioning, and supply of goods, for example, plant components or machinery, with some portions rendered offshore and others onshore, which are each attracting different taxes. And it is commonly not tax efficient, of course, to pay services related to tax on goods supplied or vice versa, and also not to pay onshore taxes on offshore services or goods. Therefore, contract splits should be tailored in view of the national regulations to optimize the tax exposure. So let's now look a bit beyond these general tax aspects and talk specifically about the permanent establishment and other tax scenarios in the jurisdictions we cover today. We start with Indonesia here. Stefan, what can be considered a permanent establishment in Indonesia, and how is it taxed?
Thanks, Marcus. Thanks for the introduction as well. Thanks everyone for joining. Indonesia has a very long history of EPC projects naturally through its geological location, many islands, a lot of hydropower, a lot of electricity related projects. Lately, we have a lot of waste to energy projects. Most of them are EPC. And based on that, I think it is very important for everyone to understand how to proceed in a complicated country like Indonesia. It can be complicated, but the moment you understand what are the complications, I am of the opinion that they can be managed and things can be handled efficiently to a satisfactory level of a foreign, particularly Western investor. What can be considered a permanent establishment and how is it taxed? Every construction contract in Indonesia is under Indonesian law considered a permanent establishment. The moment a foreign investor invests in, has a project in Indonesia, this project forms a permanent establishment. The moment you have a construction contract here in Indonesia as a foreigner, it is considered a permanent establishment. The difference is, the moment Indonesia has a double taxation agreement or an agreement for the avoidance of double taxation with the country where the investor is coming from, in that case, it might be applicable that 6 months duration only form a permanent establishment. So to answer the question quite blankly, every construction project in Indonesia is a permanent establishment. If there is a DTA, a double taxation agreement in place, then it is quite commonly under the OECD template, it is quite commonly reduced to 6 months. The moment the project durates for 6 months, it is considered a permanent establishment. How is it taxed? How is it taxed? A permanent establishment is subject to what we call a final income tax and a branch profit tax. Final income tax is basically what they call here in Indonesia a withholding mechanism. Every invoice issued from overseas, every turnover from overseas is subject to a final income tax the moment it is connected to services. Every service provided from overseas, and the E and C in EPC is basically services. The moment the turnover is related to services, the whole invoice will be subject to withholding tax, final income tax locally. The final income tax can be between 2, 3, 4%, depends on the content of the services, and it depends on the duration of the services. How can it be optimized? How do we get the P untaxed? That is the question. The EPC, the procurement, the delivery of goods, how can that be untaxed? And there is, in fact, a work around, let's not call it a work around, let's call it an optimization potential, because any delivery of goods from overseas is not subject to final income tax. So the moment you can separate the services from the delivery of goods, that moment you have already optimized your taxation, your permanent establishment in Indonesia. So if you separate them in two different contracts, that would be best. That is the clarity. If you separate it in two different invoices, in two different clearly independent of each other provisions, then that would be sufficient as well. One contract, different services, and delivery separated from the services, that optimizes the impact of taxation here in Indonesia on EPC contracts. One word to the contracts, because Marcus mentioned FIDIC. FIDIC is a very common approach to EPC contracts in the region. Not so much, to be quite straightforward, not so much in Indonesia, because a lot of regulations in the Red Book, in the Silver Book, which are quite commonly applicable, they are not very aligned with the local regulations here in Indonesia. So FIDIC, the FIDIC template, needs to be amended significantly in order to make it compliant to the local regulations. So the permanent establishment is founded immediately the moment you start a construction contract here, the moment you start a construction project, unless you are coming from a country with a DTA, which Germany and Austria and Switzerland, most of the participants today are coming from these countries. Those are having a DTA with Indonesia, or at least with ASEAN. And this is reducing the permanent establishment impact to projects of a duration of more than 6 months. The taxation is final income tax, and I mentioned it, a branch profit tax. I haven't explained what the branch profit tax is yet, because it is rather complicated, and I'm doing it now. So the branch profit tax basically results in the fact that you, as a permanent establishment, no matter if you have founded a company or a subsidiary of any kind here in Indonesia, the branch profit tax basically means that you have to perform bookkeeping. The branch profit tax means that you have to have a P&L, you have to perform the bookkeeping, you have to calculate your profits in Indonesia that you generated through the contract, and these profits are taxed then with another 10% of withholding tax. The withholding mechanism is quite the same procedure as it is in other countries in the region. Basically, the receiver of the invoice withholds a certain percentage of the invoice and submits it on behalf of the taxpayer, of the foreign taxpayer, to the tax authorities. So two taxes: final income tax, depending on the contract structure, between 2 and 4%, and branch profit tax, 10% on profit generated through the project here in the country. A further optimization of taxation in EPC contracts is, beyond this separation of service from the delivery of goods, not possible. So creativity is limited, and you just need to watch out that you have to separate everything from the services. Then you're safe to go.
Yeah, thanks. Of course, also for the practice aspects on the optimization scenarios to the extent possible. And yeah, it's of course very important if contract splitting is envisaged to, in the first step, carefully plan the taxes and look at the local tax system and of course the further impacts that from local law may derive before doing a contract split. We often in practice see that FIDIC models are just taken and used in a ASEAN jurisdiction, and often there are shortcomings, and local law is not always in line with the regulations of the FIDIC contract. So always do homework first, of course, and check the local, especially tax regulations, to efficiently split the contracts then, and then do the contract work. Okay, thanks.
And nevertheless, maybe just one addition to that, because you mentioned FIDIC. FIDIC itself, I believe, is a very positive approach. FIDIC itself has a good concept, and they're developing it on a regular basis. But it just doesn't apply. It just doesn't work as well in Indonesia as it probably does in other countries without in-depth knowledge in other countries as well. But in Indonesia, you really have to basically create a whole new contract based on the content. So that's the difference to many other countries in the region, I believe.
Yeah, thanks for this. So let's look into some other countries. We now travel north from Indonesia, looking at Thailand. Martin, when is a taxable permanent establishment triggered in Thailand?
Thank you, Markus, for the question. Also, thank you for having me. Very excited to be here. Obviously, Thailand is also an important destination for EPC projects. To be fair, over the last 2 years, business in regards to EPC was not super big, but it's picking up again. Latest project was just a minor EPC construction for solar power, solar rooftop. That continues to be an important part here, and lots of aspects of permanent establishment always comes up in these topics again and again. Similar to Indonesia, actually. Maybe we start with the local law. So the local Thai tax law states that if I have a representative, an employee, or something in between in Thailand, and I'm carrying on business in Thailand through said representative, and I'm deriving income in Thailand, then I'm having a permanent establishment. So effectively similar to Indonesia, I guess. If you just look at this provision, you can have a permanent establishment more or less immediately if you're doing an EPC cross-border contract in Thailand. In practice, we will always take a look at the various agreements on the avoidance of double taxation. Thailand has right now around about 60, I think. And you actually have to look in each DTA separately because they are quite different. There are substantial differences, actually. So a one-suits-all approach does not work here at all. And obviously, we don't have the time to talk about 60 double tax agreements, I guess. Maybe I limit myself to the most relevant to our business here, which is the double tax agreement between Thailand and Germany. And
that's a good choice, I think. Yeah.
I guess so. But it's actually interesting as well. Yesterday in preparation, I sat down a little bit and clicked through a couple of other agreements as well. It's quite different, especially like the older ones. They differ from the newer ones quite a bit. So it's really relevant where this project is located, where it's coming from. So, but in the case of Germany, similar to Indonesia, I guess we also have. So the double tax agreement also has the provision for the 6 months, right? So if I have a building site, a construction site, an assembly site, then in general I have a 6 months period for installation, setting up plants, setting up machinery plus a little bit of construction that might be necessary. So in these cases I have 6 months. However, I have another provision that says in all other cases I can have a permanent establishment within 3 months. So and this is where it can get complicated sometimes, because actually, as the first step, you want to determine, okay, what kind of project, which part of the provision is applicable to my project? Because is it 3 months? Is it 6 months? Most commonly, we end up at the 6 months. But there might be other projects where you might have a PE in Thailand already after 3 months. So that's the thing. And then also a practical problem that we run into a lot is how to calculate the 6 months or the 3 months. And that's good to know that the Thai Revenue Department, the officials in the tax authority, they take a very wide approach. Yeah? So if it goes like the Thai tax authorities would like it to go, they would probably say, like, the period starts the moment you first time thought about this project. But definitely, if you send some people over to Thailand to maybe scout the location, just to do some pre-arrangement, maybe the construction itself did not start, but it might already start for tax purposes. So that's really important. And the same is true for when does this period end. And we always try, when we advise on these projects, to be like rather conservative, to avoid any discussion, because if you have to discuss with the Thai tax authorities, you're spending money and time on lawyers and so forth. It's not worth the investment from our point of view here. So you want to plan this very carefully in advance. So so when do I have a permanent establishment for EPC contracts in Thailand? In general, I would say for our purposes, if you do an EPC project and it takes longer than 3 months, maybe. If it takes longer than 6 months, then definitely. So these are the relevant timelines that you want to take into consideration.
All right. Also from your practice perspective, do you see common approaches for tax optimization in Thailand as well?
Oh, yeah, sure. Yeah, totally. Similar to Indonesia, we would also employ a contract split here in Thailand. So what we want to do is we want to split the engineering and procurement from the works and the services rendered in Thailand. And the main purpose of the contract split is to minimize withholding taxes in Thailand. Maybe make an example. Let's say you run your entire project through a branch office. So you set up a permanent establishment, you set up a branch office in Thailand, and you want to do everything through the branch. So in this case, your entire contract value would be subject to 5% withholding tax. Can be 3%, depends a little bit, but might very well be 5%. Which obviously can be that can have a real impact on your project planning. So therefore, we always advise to split it and keep the engineering and keep the procurement offshore, and only have the services and the works rendered in Thailand. And then typically you end up only withholding taxes only at 3% when everything goes well on the services and works part, essentially. So that is the main tax purpose to split the contract here. There are also other issues. I think we're going to touch on this later, but I would like to utter some words of caution here when it comes to contract split. So what we always see again and again in practice is just poorly made contract splits. The contracts have to be made properly. They have to be separated properly, and the Thai tax lawyer really has to look at this, because if there are certain connections, even with the umbrella agreement, this can be tricky as well. If you have certain connections, then the Thai tax authorities might very well still go ahead and consider this. Well, from our point of view, essentially everything is done in Thailand. So that's a clear separation between the tasks. This is paramount. And number two is something, especially when it comes to procurement, where companies need to make sure that the local staff in Thailand is only doing services and works, and that they are not, let's say, filling out purchase orders or anything like this. Then we end up at the good old substance over form principle, and then the Thai tax authorities will again sort of say, oh, nice contract split agreements you have there, but we're still going to tax everything in Thailand because as a matter of fact, you were running the entire project through this branch office essentially. So these are common pitfalls that we see, and that really can be avoided by proper planning in advance. So keep in mind, split your contracts properly, make sure that there's a clear division between the onshore and the offshore contract, make sure there is any detrimental clauses in the umbrella agreements, number one. And number two, make sure that each side of the EPC project is doing what they're supposed to do and nothing else, because otherwise it might come back and bite you after a couple of years.
All right. Yeah, so also a common approach with contract splitting with the required caution, of course. Now let's have a look east from Thailand, coming to beautiful Vietnam. Also Vietnam knows, of course, the concept of a permanent establishment. Michael, when does a PE occur in Vietnam?
Yes, indeed. The concepts are not that dissimilar from what we've heard in the past 10-15 minutes. Obviously, and yes, thank you very much for having me on the panel, and I'm very pleased that Stefan is with us today. So Stefan, please feel free in the light of your experience to join in, and maybe we end up having a lively discussion here.
Combined knowledge, yeah.
Combined knowledge, here we go. So that definitely would be a good thing. So generally speaking, as I said, there is a lot of EPC contracting going on and been going on in the past, maybe with a little bit of a break because of the COVID entry restrictions, which, by the way, have all been lifted now as of the 15th or 16th of March. So everyone can go back and enter Vietnam more or less freely. So there is a fair bit of EPC contracting going on for a variety of reasons. One of them is that in some areas, local Vietnamese entities are kind of developing the knowledge required to implement these contracts, and in many, and shall we say, in some areas, there is still knowledge required from foreign contractors. So if you look at the areas, what kind of EPC contracting do you find here? Infrastructure is definitely there, maybe less from a Central European perspective. Renewable energy, quite a lot. So there are quite a few players in the area of renewable energy, both wind and solar, doing projects here. Consumer foods, processing and similar. There are a lot of specialist contractors from European countries doing installations here, and obviously there is a lot of manufacturing going on in Vietnam, whether it's more the simple area, maybe textile and shoes, things like that, but also these days more complicated things like electronics and electrical equipment. So all these areas may require some sort of construction activity, which may be undertaken locally or through foreign contractors, and also some installation work, bigger or smaller, which may fall within the definition of construction or not. So if we look at this, so first of all, I would say, picking up of what Stefan and Martin said, I would say, generally speaking, in Vietnam, things are not complicated. They are just sometimes a little bit different. But once you took the time and the effort to look at the differences and appreciate why things are the way they are and how they need to be dealt with, then actually most of the projects are manageable, and there's also a certain degree of flexibility which can be applied in terms of choosing the right approach for your specific EPC project. So the first item we want to look at today is the when do we have a PE? So I think if you look at the slide, there's nothing which will greatly surprise anyone. Basically, and I think the important thing to mention is that we're going to look at the tax calculation methods a little bit later. And I think the important thing for the planning to remember is that a PE as such is not necessarily a good or bad thing. So it may, depending on your particular project, depending on the how it's structured, depending on the taxation, having a PE may be a good thing or it may be a bad thing. So therefore, a little bit of preparation, or not a bad thing, shall we say, expensive thing. So therefore, a little bit of calculation and preparation is required here, since there isn't an obvious answer to all the projects in terms of that's the way to do it or that's not the way to do it. So if we just look at the slide, as I said, nothing greatly surprising here. So what are the elements of a permanent establishment? It's a business establishment of some sort, which is fixed to a certain degree, and the enterprise which runs the permanent establishment carries out at least partly its business activities through the permanent establishment. Obviously, this is subject to interpretation, but that's just how it is. In terms of, I can maybe pick up on what Martin said, because the items in respect of the DTAs, double taxation agreements, are kind of similar. So what if there is a DTA in place, which there is one for Germany, then again we come in with the familiar 6 months 6 months rule. So then it is that there is definitely a PE if the respective activity is undertaken for 6 months and more.
Thanks, Michael. So we take from this that PE concept in itself doesn't bear too many surprises, but you just mentioned that there are specific taxation methods. Is there anything which is quite unique in Vietnam? What taxation methods are available to a permanent establishment?
That's right. So the way, in a way, the concepts are sort of to some extent familiar. We've heard it all before in terms of withholding tax and things like that. But I think it would be useful just to see the choices which one tends to have in Vietnam on one slide, to sort of summarize, to have them summarized, and they appreciate maybe the importance and the impact which they may have on the actual taxation of the amount of the taxation of a particular project. So I think the starting point, we need to again think about the fact that in Vietnam there is a withholding tax. It's called the foreign contractor withholding tax. Again, it's the same as in other jurisdictions. It is not a separate tax. It's just a method of collecting existing taxes, which are in most cases CIT, corporate income tax. If there is an individual involved, quite unlikely, but then it will be personal income tax. But in most cases, it will be corporate income tax and VAT, value added tax, basically. So it's just a method of collecting these two taxes. So let us just have a look. What are the methods of taxation available? And then in the next step, if you just let me explain, there will be certain taxes are only applicable in certain circumstances. So if we just the broad concepts at this stage. So we have if there is a permanent establishment, or as a matter of fact, just a provision of services into Vietnam, then this will have to be looked at. So the three different methods are the credit method. So basically, the credit method can be compared to the taxation of a company. Right. So you have effectively you register the permanent establishment. So there is a permanent establishment, and the permanent establishment is registered with a tax authority, and then obtains a VAT number, VAT registration. VAT is paid input output the normal sort of way, and CIT is declared on the profit, not on the invoice amount, not on the turnover, on the profit. So it's effectively, this taxation method is comparable to a company in broad concepts. Then there is the withholding method, so that's effectively the opposite to it. So then here the entire tax of the permanent establishment, or in fact, it can also be just a provision of services in this particular case, is collected through the withholding tax. So this tax is applied to the invoice value, which is paid by the local Vietnamese entity. So in there is a VAT element and a CIT element, and effectively then depending on the provision of the contract, but usually the standard method would be that the contract price is paid without the VAT as CIT, which is then withheld and deposited on behalf of the contractor. The rates here depend a little bit on the activity undertaken, what it is, but the CIT element would be between 1% and 5%, and the VAT element will be between 3% and 5%. So, for example, the standard rate on services is then 10%. Just very briefly, we touched upon the split of contract in the service element and the goods element, for example. Yes, also here it makes sense to think about it, but only in the scenario in which you have the withholding tax being applicable to your project. And the hybrid method is effectively a mix of the two. So there is a VAT registration and filed in accordance with the credit method, so a bit like a normal company, and CIT is withheld on the invoice value being between 3% and 5%. So all these things, basically, whether it's expensive or not expensive, it depends on the particular case. So you need to sort of calculate, have the methods in front of you and calculate it, and then just see what makes sense. There are certain limitations to this. It's important to mention. So basically, the withholding method is always applicable, while the credit method and the hybrid method is only applicable if the contract duration of the foreign contractor implementing contract is more than 183 days, and if there is a PE in Vietnam, which is basically the last slide which we discussed. And a requirement is also to apply these two methods is the application of Vietnamese accounting standards. So then the revenue and the profit can be calculated accordingly.
Great, thanks, Michael, for this insight. With a look at the time, we move on a bit now, but we always keep properly in mind that Vietnam knows the foreign contractor withholding tax. And any further detailed question on this hybrid tax calculation method can, of course, always send the follow-up to this event by email, and we'll be more than happy to elucidate more on the calculations for this taxation in Vietnam. Beyond the tax planning that we have now discussed, there are also other aspects, of course, which should be considered when doing EPC projects. So let's now look at some of these, which can also be quite essential for the planning of the projects. Many countries in Southeast Asia have, besides the tax aspects, imposed further requirements in local investment regulations, which also deserve careful consideration. It is often not sufficient to simply register a tax number for a permanent establishment to commence operations. So let's take a closer look at these aspects now. Again, starting with Indonesia. Stefan, what are the business licenses or permits necessary to conduct EPC operations in Indonesia?
Yeah, thanks for that. Thanks for that question. Yes, Indonesia does have implemented a regulation related to the incorporation requirement of EPC contracts or EPC provider. So the moment you provide EPC contracts to a local project, that moment is where you have to be clear about the fact that you have to register either a representative office or a, we call it PMA, a local company foreign invested. PMA is the Bahasa wording for foreign invested. PT is a limited liability company, basically. EPC contracts are only allowed at large scale for foreign investors. Foreign investors are not allowed to be a project partner in medium and small scale projects. They can be subcontractors, they can be suppliers, they can be allocated a certain service. That's no problem, but they are not allowed to be the main contractor in an EPC contract. They are not allowed to perform this turnkey project. Large scale needs to be defined. Large scale is anything related to the turnover or the financial capabilities of the investor. So large scale in terms of representative office, and large scale in terms of company need to be separated. So when you have a project of, let's say, let's start different. You have a project where you believe this is a project of a certain period of time and you will not have additional projects in the country. So it's a one-time project, basically. In that case, you might want to consider a representative office because it is more flexible. It requires less upfront investment and it requires less administrative procedures and administrative support throughout the operation of the representative office. But the disadvantage of a representative office is that every EPC contract in this case needs to be at least 100 billion IDR. That is approximately $6 million. So any contract above $6 million, you can use a representative office as your local office that is representing the basically project. We call it a BUJGA, KP BUJGA. KP is the short form for representative office, and BUJGA is the foreign construction company rep office. So you are allowed to perform EPC contracts, projects under this contractual relation in building construction, high-rise, and every kind of construction activities, and civil construction, mainly infrastructure. The moment, however, you're going into a high-risk project or high-tech project, high-cost project, particularly anything related to large-scale projects above a value of, it's a very vague value, but above a vague value of approximately $25 million. In that moment, you need to have to go for a company registration. Whereas we say that an annual sales in this case is 50 billion, so $3 million only, the requirement to form this kind of company, but you have to found this company, you have to form this company in these segments that we have listed here: high risk projects, high tech projects, and high cost projects. The definition, the clear definition, then depends on the regulations, depends on the project itself, but there it depends on the particular circumstances. So the requirements for representative offices and companies are different. So the requirement for a representative office, we need a straightforward business license. That's nothing complicated. Provision of a service based on a construction work contract. That's also nothing complicated. Deployment of qualified contracts, also not a complicated topic. These are all fulfilled by a typical EPC contract. But what is more important is a joint operation. So we have a representative office which needs to enter into a joint operation with a local construction company, with a local Indonesian EPC provider. So the representative office needs to make use of a local EPC provider and needs to perform the EPC contract, this particular project under this joint operation. In that sense, the joint operation, the JO, is basically the permanent establishment that we mentioned before. This joint operation is the one subject to taxation. This joint operation is the one that is basically performing the EPC contract. Whereas the representative office is only representing the contractor from overseas in the joint venture, joint operation with the local EPC provider. For companies, we have a different option, a different requirement. For companies, we need to have at least one shareholder who is a local Indonesian EPC provider. So basically, construction companies, large-scale construction companies from overseas need to enter into a joint venture with a local Indonesian EPC provider. So in any way, you need a local construction partner, basically. In rep office cases, you need it as a joint operation, and in the company, you need it as a joint venture. The investment value is relatively low compared to the annual sales requirement. The investment value is 10 billion per business scope required, per business scope registered. And for EPC contracts, you normally register 2 business scopes, construction and services. So that would then be 10 billion per business scope, 20 billion, $1.2 million as a cash upfront injection into the company. So not a big deal compared to the requirement of the 50 billion annual sales, which is already 2.5 times the value of the cash injection into the company. So briefly wrapped up, when you have a EPC contract with a local project owner, you need to either form a representative office or a company. In any case, you need to have a local cooperation partner in form of a representative office. You form a joint operation, which is basically then the formation of a permanent establishment. If you have a company, then you need to get your partner on board as an actual shareholder in the entity. And then the company will be providing these services and will be basically taxed.
Yeah, thanks, Stefan, for this
brief overview.
I think it's quite an interesting feature in Indonesia that rep office can do services in construction projects and
as long, exactly, sorry to interrupt, as long as they enter into this joint operation with a local provider.
Enter into a joint operation, and of course, as long as several other requirements apply, so it's not as easy, you know, that's important taking as in other countries where you have very simple establishment requirements for rep offices. So don't be misled by the fact that this is in fact the rep office. There is quite some planning behind it if you want to go this way, and sometimes you might want to consider that a PT-PMA as a respective company, especially if you plan long-term projects in Indonesia, might make sense as well. Looking at Thailand again, Martin, do foreign companies require permits for conducting EPC projects in Thailand?
Yeah, they do. But indeed, I was also surprised actually to learn that a rep office in Indonesia can do this. So a rep office in Thailand cannot run an EPC project. Absolutely not possible. So in Thailand we have an act. It's called the Thai Foreign Business Act, and the Thai Foreign Business Act essentially states that foreigners, if they want to render any restricted business activities in Thailand, then they need a permit, a foreign business license, we call it. And so if you do an EPC project in Thailand, then you have essentially 2 options. Either you have a subsidiary in Thailand, or you as a foreign company want to establish a branch office in Thailand. So these are the 2 options that you have here. So, and either way, you will have to check if any of the planned activities fall under the restrictions of the Thai Foreign Business Act. And the bad news here is that engineering, construction, as well as procurement is actually a bunch of different services, are all restricted by the Thai Foreign Business Act. One exemption applies in terms of public infrastructure projects, but German companies are not involved in public infrastructure projects so much anymore. So this rarely applies for our clients at least. But in general, you will have to deal with the fact that you need to apply for a foreign business license for the activities rendered in Thailand. Here again, calling back our contract split discussion earlier, obviously if you have certain activities rendered abroad, then in this case foreign business license might not be necessary. Though the Thai authorities, they take a rather wide approach and then they say, oh, also services rendered abroad might require a foreign business license, but that's a story for a different day, I guess.
Is it complex to obtain such a foreign business license? How much time planning in advance should developers have?
So unfortunately, it is not overly complicated, but it is a little bit lengthy, especially right now. You have to plan in advance right now probably rather 6 months actually, if you depending on the license that you are applying for. But yeah, the process is a little bit complicated. Is number one, it is complete in Thai language. All the forms are in Thai language and so forth. So it's not in English or anything like that, which makes it just practically complicated for a foreigner. Number two, there's a fair bit amount of communication necessary between the Department of Business Development and the applicant. Maybe. So if you file an application, and then the officer looks at it, and then he comes back to you and he will ask clarifying question. Oh, do you mean this? Do you mean that? Could you provide this document? Could you provide that document? So there's a fair bit of communication happening before the application is formally accepted. Once it is then formally accepted, it goes up to a committee, and which is sort of agreement between some politicians, some administrators, and so forth, and they will check, okay, is granting this license to a foreigner, is this beneficial to Thailand or not? And usually, so it's never a guarantee, right? So it's not you file the application and you get it 100% of times. But for EPC project, in our experiences, chances are pretty good, because usually having this project being conducted in Thailand is beneficial to Thailand, and you can always argue, okay, I need foreign expertise here and so forth. But it's unfortunately never guaranteed. So it's a fair bit of work going into this. Also, what you have to keep in mind, these applications are usually filed for specific projects. So it is not something like, okay, now I have filed my foreign business license application, now I can do EPC projects in Thailand forever and ever and ever. This is not how it works. It's essentially for each project. It depends a little bit on how it is formulated later on in the license, but in practice, normally a license is issued for a specific project. So if you want to do another project in Thailand, you have to apply for a new license. And
can I ask one question in between? Sorry for interruption. Sure. If we have one project, one license, and probably subsequent further licensing requirements, we just heard that Indonesia imposes certain minimum capitalization requirements. Would this, from financial perspective, also be observed when applying for a business license in Thailand?
Yeah, essentially, per each activity that you're applying for, you will have to remit a certain amount of money, either remittance or paid up registered capital, and so the minimum amount is 3 million baht. Usually we are, which is what's that, 75,000, 80,000 euros per activity, and so in general you want to tailor the application that this minimum requirement is sufficient. It depends a little bit. If you it depends a little bit. Usually you can get away with 3 million baht. And then it depends on how many activities you are applying for, right? So when we're talking about engineering, that's a separate activity. From construction, there would be a separate activity. From procurement services. So worst comes to worst, you have to apply for different licenses. There are certain, sometimes in certain turnkey projects, you can argue that construction and procurement is essentially a service rendered in Thailand. If I have a turnkey project, and then you are good to go with one license. But you can see it depends a little bit on the circumstances and requires a little bit of planning to also minimize required capital in Thailand. Though maybe just one of the money does not have to stay in the bank account or anything like that. It's proper working capital, right? You can pay your staff or the other expenses that you have in Thailand. And once the project is finished, you also get it back. Everything that remains in Thailand, you will be able to get it back. It's a little bit of a process. It's a little bit of red tape, but you will get it back. So you ask a CFO in Thailand, it always takes too long.
Yeah, interesting, but yeah, especially the fact that foreign business licensing is required for each specific activity dictates, of course, the need to very carefully plan how to structure the administrative proceedings. Thanks a lot for this insight, Martin. And how is it in Vietnam, Michael? What are the business licenses or permits necessary to conduct EPC operations in Vietnam?
Okay, I would say again in Vietnam maybe it's sort of slightly different than what one may expect, but again I would not say it's difficult. So once it's the idea is clear what needs to be done and the alternatives available, then it's actually I would say probably manageable. So my first sentence would be I join with Martin on the rep office, representative office. Please do not run EPC contracts through a representative office in Vietnam. That does not work, since a representative office is not allowed to have an income and is also not should not well cannot be running business activities.
That remains an Indonesian specific, yeah.
Which, yes, so there seems to be a Indonesian speciality on this one. Generally speaking, if you are talking about EPC contracts, there are two ways to approach this, or three ways, shall we say. So the first one would be to subcontract the whole thing to a local contractor, but then it's not an EPC project; it's a kind of it turns into a local project. The other idea, especially interesting if there's a series of projects, or a company comes into Vietnam and thinks, well, I've got one project, but probably there will be more in the future. Then there's always an option of setting up a subsidiary, a company with a specific business scope, construction activities, technical services, whatever. Then this needs to be considered carefully, and then through this entity, the EPC project can be delivered, and future EPC projects at a later stage. Obviously, one should generally sort of think a little bit that the contracting works. So in terms of the parties involved, so if you have a local entity, then you would contract between the local entity and the Vietnamese customer rather than the HQ entity and the local customer. That's probably easier, but these are kind of details to be considered while looking at it. So but this again, same as the subcontracting model, it turns the entire thing into a local thing, because you have a subsidiary, which is a Vietnamese entity, which then contracts with the Vietnamese customer. Then the other method is, which is also available, is the so-called PCA, permit for construction activities, which can be set up. The PCA is basically it's a compliance requirement. So quite often, if you look at these EPC ideas, then people jump immediately in the tax items because that's kind of similar in all the countries. In Vietnam, it has to be remembered that this is also, obviously, it is a tax item, but also it is a compliance item which needs to be looked at. So if there is no local entity providing the service, for example, a subsidiary which I mentioned, and it is a construction activity, in the law there is a rather wide scope of construction activities, what it means. So it's installations usually of all sorts, and so I would say on one side, if it's a IT service, for example, then it's probably not a construction activities, but anything about installation and anything about constructing, fixing, it's usually within the scope of a construction activity, which then requires, if there isn't a local establishment, to apply for a PCA. Generally speaking, the effort required to get a PCA is probably similar to setting up a new company. But if there's only a one-off project, it may make sense to think about it. There are a number of formal requirements while looking at the PCA, while applying for it. For example, the foreign entity running the EPC project and applying for an PCA has to show certain professional licenses, professional expertise, the very fact that they are able to conduct the project to a certain level of quality. And also, interestingly and importantly, there is an obligation to some parts of the work have to be subcontracted to local contractors. So the entire project cannot be run through the PCA. It can be subcontracted, and practically it means once the PCA is there, it gets a executive office, which is kind of, it's not a local entity, but it's a local registration, which then, for example, can apply for immigration permits and things like that. But I think that's probably our next topic.
It is indeed, yes. Yeah, thanks for this insight. And as a conclusion, of course, each of these countries has quite specific requirements to be observed when doing EPC projects in the respective jurisdictions. But last but not least, yeah, it is also important to plan how foreign staff, for example, technicians or other experts which are required for onshore works, can be temporarily deployed from overseas to the project side. Stefan, what are the general immigration requirements for staff in EPC projects in Indonesia? Is a local sponsor, for example, required?
Yeah, thanks very much. Yes, indeed, we do have the requirement of local sponsor. I come to that soon, but in general, there is no particular requirement to staff of EPC contracts. What we call them here in Indonesia is working visa, working staff visa. We have different types of visa here in Indonesia, tourism things that one we leave aside, but even though many EPC contractors come on tourism visa and then try to convert it into a business or working visa, which is at the moment not possible anyway, but also in the past not 100% a legal procedure. So stay away from entering any country, I believe, in the region, and I believe I talk for my colleagues Martin and Michael as well, for Thailand and Vietnam. Stay away from entering any country without any visa and then in expectation to convert it locally. So don't do that. Might be faster, but it is incompliant and not 100% sure. So what we have is we have two different types of visa which we can think of, which is a business visa and a working staff visa. Working staff visa basically means you get your staff, your engineers, your contractors, your construction stuff into the country for a certain period of time. The certain period of time needs to be defined, can be a maximum of 3 months, can be extended 1, 2, 3, 4, 5 times, indefinite times. It can be extended, but it has to be extended every 3 months. So that is for staff that is actually doing the work, the construction work, etc. You also have is what we call a business visa. Business visa, you are not actually allowed to work in Indonesia, but you are allowed to have business meetings. You're allowed to have certain alignments, for example, with the project owner. If you are the manager, if you are the key person overseas, the manager in charge, for example, for the EPC contract as a whole from the mother company in Germany, for example, in overseas, then you can come on a business visa and you can have alignment meetings with the project owner, but you're not allowed to perform the actual construction activities. For this construction activities, you have the working visa in detail. Both of these visas need to be sponsored by either the project owner, but quite normally by your local partner. I mentioned before, even though representative offices are quite uncommon structure to provide these EPC contracts, but you have to have a joint operation with a local contractor, with a local construction company, and this joint operation will then be the sponsor. This joint operation will then be the sponsor of the visa for each of the individuals that come into the country. In case of the company, in case you go for a company, then you have founded a joint venture with a local construction partner, and in that case, the sponsor will be the company, the PT PMA. I mentioned it. PT is a limited liability company, and PMA is the foreign vested enterprise. So the PT PMA will then be the respective sponsor. What is very important, and I come very briefly only, Marcus, allow me for 2 minutes to come back to taxation, because in this case, individuals that come to the country, they are subject to a personal income tax as well. Personal income tax as a non-tax resident. I think that is something many investors tend to forget. I put it here at the end because it is important to understand. Many investors, many contractors tend to forget that anyone they send into the country, I know it from other countries in the region as well, but also for Indonesia, this applies to Indonesia as well. The moment you send someone into the country, this individual is subject to personal income tax. Personal income tax, yes, okay. Investor might think, yeah, but I'm a tax resident. I spend more than 185 days in my home country, in Germany, in Switzerland, in wherever. But that is not relevant because we also have the non-tax resident status in countries, particularly in a double taxation agreement. So the non-tax resident status basically means that even though you are a tax resident in one particular country, you will still be taxed on the income that you generate in another country. What is the income generated? The income generated is quite normally put into proportion of the world income compared to the days that you spend in the respective country. It's a really complicated and complex calculation where you need to provide a lot of sources of income. So working with a certain nominee income or working with a certain income allocated to your work in this particular country where you are, for example, doing construction works, that is normally the way forward. So that is a complicated topic. That is a topic that no one should forget and which is being targeted in Indonesia at the moment significantly, and we see a lot of EPC contracts where this becomes a problem. So this is something to keep in mind. I know topic was immigration. Put briefly, you need a sponsor. You have 2 visas that you can choose from, and then you can easily come into the country. Since yesterday, by the way, without quarantine.
Yeah, we are flexible with our topics, of course, and this PIT aspect is indeed crucial to consider when sending staff to Indonesia. So thanks for adding this as well. Yeah, we will not go deeper into COVID-19 related immigration requirements, which A, change quite often anyway, and B, this would be too much content for the time that we have. So having looked at Indonesia, Martin, what immigration requirements apply for foreign staff in Thailand?
Yeah, thanks. And thanks for not going into COVID details. I'm very glad to have to cover this right now. Indeed, in Thailand, I need 2 things. I need a visa for staying in Thailand, and I need a work permit for working in Thailand. There's actually separate documents, also separate authorities issuing this. One is issued by immigration, the other is issued by the labor departments. But indeed, for EPC projects, I need both. Similar to Indonesia, there's no special requirement for EPC projects. Visa and work permit requirements just apply regardless of what kind of work you're doing in Thailand. So in general, maybe we start with the visa. In general, you will need a non-immigrant business visa, just the typical business visa that you can apply for in your local consulate or embassy and abroad. And then you come to Thailand. And then once you are here, you can, with this non-immigrant B visa, you can apply for a work permit. It is important that other types of visas are not suitable for applying for a work permit in the first place. So you have to come in with a non-immigrant B visa, or yes, some exemptions apply, but it's really not important in this case. And then next thing is, how long does your project last in Thailand, especially for the visa issue? So typically what we see right now, you're going to get issued maybe a non-immigrant B visa for 90 days. Right now, typically not even multiple re-entries. You have to get multiple in Thailand and separately. And if your project lasts longer than 90 days, you would probably have to apply for a long stay visa in Thailand, which then would permit you to stay in the kingdom for 1 year, sometimes even 2 years. For the entire duration, then you have to extend it again. In order to be issued such a long stay visa, your employer has to your employer in Thailand has to provide certain information, and namely, there is a so-called quota. Essentially, for each foreigner who's staying in Thailand, you have to employ a certain amount of Thai staff. And there are some differences. If you're working with let's say you have a subsidiary in Thailand, foreign owned, right? It's just a company limited. In this case, a ratio of 4 Thai people to 1 foreigner applies. Different if you're just opening a branch office in Thailand. In this case, I only have a ratio of 1 foreigner to 1 Thai person. So this is always important to keep in mind.
Can this be changed under investment promotion in Thailand?
Well, yeah, in theory, it can be changed on investment promotion, but so investment promotion only it's not applicable for branch offices in the first place. And number 2, it might be difficult to secure an investment promotion for a small EPC project, because it can be possible, but then you're looking at way longer term projects, I would say. We do not see this very commonly. But yeah, in theory, it's possible. Also, there are other requirements that can minimize this. For example, if you have like a person who is married to a Thai person, the requirements can be lowered. So there are some exceptions, but in general, it's easier to keep these figures in mind as a rule of thumb. So number 2 is the work permit. You come to Thailand, then you apply for a work permit here. There are a couple of documents you need to file. The important part is that an employer has to show a certain registered capital per work permit. And again, there are differences between a company employing you and a branch office employing you. A company employing you, in this case, I need 2 million Thai baht in registered capital per each work permit. And there might be an upper limit of 10 work permit. Also depends a little bit on the case. For branch offices, I have to bring in 3 million baht per work permit. So that's always important to keep in mind. How many foreign staff do I really need in Thailand, and how much money do I have to bring into Thailand? Also, foreign staff in Thailand has to receive a certain minimum salary, which funnily enough differs from between the nationalities. There's a different minimum salary applicable to a person from Germany to a person from Hungary, for example. So in the German case right now, it's at 50,000 baht, which is not a lot, but this has to be paid to the foreigner in Thailand. And similar to what Stefan just said, these amounts paid in Thailand are subject to personal income tax in Thailand. It's not a lot, so therefore it's not much, and you can handle everything else. There are some other tax provisions that come actually in handy here when it relates to other income in abroad. But keep in mind, at least the money paid to you for work by an employer in Thailand is subject to personal income tax. So that's that. But maybe really briefly, sorry, I keep yapping. There's one exemption, which is called the urgent duty work permit. If I have very, very urgent work with a limited duration, essentially 2 weeks, then I can apply for this urgent duty work permit, which is just way easier to obtain, and actually can be also applied for with a tourist visa, funnily enough. And again, it's just very limited in scope. Only certain activities are covered in the first place, and it's just for a job that has to be done in 15 days. So essentially in 2 weeks. So if you have someone who has to operate a special machinery or something, and you need this person to fly in urgently, otherwise you cannot erect your plant or whatever, then maybe the urgent duty work permit is a suitable solution.
Yeah, thanks for this. So we see some similarities also to what we heard from Indonesia. As Stefan indicated at the beginning, get your visa in advance. Don't try to switch in the country. And of course, be prepared to have a local vehicle to apply, for example, for work permits in the country. It cannot be done remotely from overseas. Michael, which immigration requirements apply for foreign staff temporarily deployed to work on-site in Vietnam? Can application proceedings be conducted by a foreign entity in Vietnam, or is it likewise in Thailand and Indonesia?
Yeah, interesting question. I think this one I can probably keep fairly short because the concepts are kind of similar to what was already discussed in context of Indonesia and Thailand. Maybe the complexity is a bit less in terms of how many different types of permits they're applicable and so on, but I think the general ideas are kind of similar. So if you look at Vietnam, they're basically for foreigners entering for the purpose of working on an EPC project. Again, same as in Thailand, general immigration rules apply. So what are the 3 items you need to look at in terms of your immigration for foreigners? So there is the right to enter, that's the visa effectively, and then there's the right to work, that's the work permit. They're all separate things. And then there's the right to stay, which is a temporary residence card or a permanent residence card or similar. So a foreigner working in Vietnam, entering Vietnam and then working and staying will need a mix of these things, one way or the other. Let's not go into all the details. I mean, there are obviously work permit exemptions for foreigners having Vietnamese spouses and all sort of other things, but let's leave this aside. And also, obviously, if a foreigner does have a TRC, that this then in normal times it replaces the visa and includes kind of the right to enter. So one thing probably is not recommendable here, but it's the same in Thailand and Indonesia. Do not come in and try to do your EPC project on a tourist visa. Obviously, it may be possible. Just turn up in the airport and say, I'm just going to look around and so on. But I think there are many examples in which these things went wrong. In particular, if there's something happens, there can be an inspection at site. There can be an accident or something happening, and then usually these ideas of doing things on a tourist visa then collapse, and then on top of the item at hand, there are more problems to resolve. What is quite interesting also to remember, there is a mechanism in Vietnam, the so-called work permit exemption, which basically works like this. So if you have a foreigner and she stays for less than 3 times a year, each case less than 30 days, then the activity can be conducted without a work permit. So only the visa, business visa or similar, will be required to stay. In terms of who can apply for this thing, if you, for example, have a PCA, permit for construction activities, then you have an executive office, which again, as I mentioned earlier, it's not a local entity, but it's a registered something in Vietnam. So this executive office can then apply for the for a visa and for a work permit. If there is no executive office, then the local customer will have to do the application. The one thing which is not possible is that the employee directly applies for a work permit without having a local sponsor, whether it's an executive office and or the customer. The one last thing I just wanted to mention is similar to Indonesia in respect of personal income tax. Same thing, even if it's 3 months, 1 month, the activity work in Vietnam triggers personal income tax liability, regardless the fact that the employee may be a tax resident in some other countries. And to deal with the question maybe by saying, oh, but no one will notice, then we can say, well, there's an obligation of a legal obligation placed on the Vietnamese customer, saying if they have foreigners working on their project, then they are under the obligations to notify the tax office. So that's how they will know and find out. So PIT, personal income tax for foreigners, even if it's a short period of time, it has to be dealt with, and the obligation to file a personal income tax return is one of the employee. So it's a personal obligation of the employee. In many cases, obviously, the employer will assist and help, but it needs to be done same as Indonesia.
Okay, yeah, thanks. I think that was quite a nice run through a lot of issues now, and we can conclude that there are several aspects also beyond tax planning that should be considered prior to entering into EPC projects. So now, coming close to the end of the session, we would of course also like to give you, dear listeners, the opportunity to ask some questions. So we come to the Q&A part now, and I see in the chat that some questions have already came in. I'll pick some, but yeah, given the time, we might not be able to respond to all the questions. Anyway, don't worry. Each questions that we cannot answer now live in the panel will not be ignored, but you will then get individual reply by email from our side after this panel discussion. So here we have one quite practice-oriented question regarding Thailand. Martin, is it difficult for foreigners to open a bank account in Thailand?
Well, yeah, but so let's put it this way. It is not necessarily difficult right now. So the biggest obstacle, especially over the last 2 years, is the KYC requirements in the banks here. Especially they. So first of all, they ask for all sorts of documents, and sometimes, especially German family-owned businesses, are sort of reluctant to disclose all of that. Number two is, if you want to have bank signing authority, typically what you have to do is you have to come to Thailand and have to sign in front of the officer, which was rather cumbersome over the last 2 years. Unfortunately, there's very few banks who could sort of deal with this by having a signature done in a different country with a cooperating bank or whatever, except for Deutsche. It was possible there for our client. But other than that, it was sometimes necessary to have to give someone in Thailand bank signing authority, because right now you could not come in. Other than that, it is a little bit of a process, but absolutely possible. You just have to be prepared to give lots and lots and lots of signatures, lots and lots of documents. But other than that, it's doable. And now, since travel to Thailand is again possible, I will be looking forward to this being easy again.
Okay, then let's take a look at the questions one more. Here's some more regarding Thailand. Here's one for Indonesia. Are there any local specific taxes to be observed for such contracts, EPC projects in Indonesia?
Local specific taxes in terms of special EPC tax, we don't have a special EPC tax, nothing like that. There is the taxes that I mentioned, the final income tax, there is the branch profit tax. The final income tax is basically withheld in way of withholding method, right, from the project owner. The percentage depends on the content of work, on the content of the contract. Then the branch profit tax is basically what is the profit generated from the project. For that one, you need to do a cash and bank book and a simple P&L. And the third applicable tax would then basically be the third applicable tax would then basically be the personal income tax, which we mentioned just now with the immigration. I mean, that is not related to the entity, that's not related to the contract, but for the individuals that come from overseas. For this particular project, I would also consider that a relevant tax to be considered during the whole period of the PEPC project. Other than that, there's nothing. There's no additional tax, except when you certainly form a entity of a PTPMA, the company that we mentioned in that previous slide. Then you are certainly subject to the full taxation scheme of Indonesia that is applicable to companies. That is a CIT, that is a VAT, a corporate income tax, value-added tax at a value-added tax now at 11%, recently increased, or towards the 1st of April, increased by 1%. But other than that, no special EPC tax, if you want to put it like that.
Okay. Let's see. We have something for Vietnam here. Also one question. Well, this one was partially covered. Michael, are there specific social security contributions applicable for foreign staff working on site in Vietnam. I think you briefly touched this, but maybe you want to say a bit more about social security obligations that staff might have in Vietnam.
Yes, I think that it needs to be considered, and the answer here is it depends. As quite often in these things, so it depends on the structure of the employment of the employee. So basically, just give you the overall idea here. If there is a labor contract, which is a local Vietnamese employment contract, to which the foreigner is subject to. For example, if you have the subsidiary and the subsidiary employs the foreigner, or if there is for some other reason a local employment contract, then yes, the employment will be subject to generally subject to social security in Vietnam. If the employment is not through a local labor contract or local Vietnamese employment, then generally there won't be any social security. So, for example, if the employee remains employed by some foreign entity and only enters on a visa and work permit sponsored by the Vietnamese customer, then there will not necessarily be a labor contract, in which case the PIT obligation remains, even if the salary is paid in Germany or some other countries, so the PIT obligation remains. However, in this particular case, there will not be a social security membership, compulsory membership.
Okay, many thanks. I think we are coming to a close then. From my side, thank you, dear colleagues, for giving us insight here in this wide and complex field of EPC project planning in Southeast Asia. We could, of course, only touch some essential points, essential from our view, but individually every project bears its own challenges. If you have any further questions, you can, of course, anytime address us. Our contact data can be seen here on the slide. Thank you also, Bettina, for the nice technical support from the background. And I now hand over the floor to you for your final closing remarks. Thanks a lot.
Thank you very much, Markus. It was my pleasure, of course, to support from the back end. And thank you very much to all of my colleagues for their, lively insights into the specific challenges and opportunities in the region. And of course, thank you everybody for joining us today. Like Markus already said, due to time issues, we will not be able to come back to all of the questions. But it was my pleasure to register every question coming in, and we will, of course, come back to you bilaterally by email to answer your questions. And should any further questions come up later on, just feel free to pass on these as well. Like always, this session has been recorded and will be made available to you online later on. And as a participant, you will receive the link automatically, so you may recap with your colleagues anytime you wish. And of course, as well, if you would like to have the slides that Michael and Stefan used to illustrate their explanations, just drop me an email and I'll be happy to share these with you as well. So thank you very much, everybody. Once again, all stay safe, take care, and have a great day or a great evening ahead. Thank you very much and see you soon. Bye.
Bye-bye. Thanks.
Bye-bye. Thanks for having.